The Federal Communications Commission just moved to scrutinize LGBTQ content on television. GLAAD called it an alarm. Most coverage called it censorship. But here's the question a lot of people aren't stopping to ask. What legal argument is the FCC actually making? Because the argument it's using has implications that go well beyond LGBTQ content. And if you understand the argument, what's happening makes a lot more sense. The FCC's authority comes from a statute that prohibits obscene, indecent, or profane content during certain broadcast hours. The Commission hasn't said LGBTQ content is obscene. That would be immediately struck down. What it's doing is using the threat of indecency reviews to pressure broadcasters. You don't need to win in court to create a chilling effect. You just need broadcasters to wonder if a storyline is worth the legal exposure. The GLAAD report noted that studios were already backing away from LGBTQ characters, not because of a ruling, but because of the regulatory environment. That's the mechanism. Threat without enforcement. Uncertainty is a tool. Now connect this to something the Supreme Court just decided. In a ruling on conversion therapy bans, the court held 8-1 that restricting what a therapist says to a patient is a viewpoint discrimination, a violation of the First Amendment. That ruling is being cheered by people who oppose conversion therapy bans. But here's what the ruling actually says. If therapy is protected speech, the government cannot regulate what a therapist says based on viewpoint. That means banning conversion therapy is unconstitutional. It also means the government cannot restrict gender-affirming therapy. The logic cuts in both directions. You cannot have a ruling that protects anti-trans speech and use it to justify restricting pro-trans speech. Either the government can regulate therapeutic speech or it can't. The court chose can't, which means the same ruling being used to attack gender-affirming care also protects it. What you're seeing across the FCC action, the conversion therapy ruling, and the SCOTUS sports cases is a pattern. Regulatory pressure that doesn't require a final ruling to have an effect. Legal reasoning that gets applied selectively, protecting speech when it's anti-trans, restricting it when it's pro-trans. And a chilling effect that shapes behavior before any law is enforced. That's not a conspiracy. That's how regulatory pressures work. It doesn't need to win. It just needs to make the cost of resistance feel higher than the cost of compliance. The through line in all of these cases is a claim about consistency. The FCC claims it's applying existing indecency standards. The SCOTUS majority claims it's applying First Amendment neutrality. The states claim they're applying sex-based classifications neutrally. None of these applications are consistent. And inconsistency isn't just a legal problem. It's an argument that something other than the stated principle is doing the work. Because if the principle were the principle, it would apply in both directions. And once you notice it doesn't, the argument starts to look extremely different. Sources are in the description. Y'all be well, and I'll see you in the next one.